If you're a director of a company and you receive a statutory demand, my view is you should never ignore a statutory demand, regardless of the situation. So either you can't pay right now, in which case you need to proactively communicate with the creditor, because most creditors, they just want to know what they're going to get paid and when they're going to get paid. And most creditors are flexible. Most creditors are at this stage because you've put your head in the sand. This is the time to proactively communicate and resolve the debt that's owing. And in my experience, most creditors will give you some time if they have some certainty on that time. If you can't pay, again, you shouldn't ignore the statutory demand. And if you can't and won't, and it's not going to be paid, it doesn't matter. You shouldn't ignore it. What will then happen if you do is the creditor will issue a liquidation application to the High Court. And from there, a liquidator will be appointed, and it won't be a liquidator that you have any fun with. This liquidator will go in, they will investigate your shareholder current account. Have you been taking drawings? That's a loan and it's repayable on demand. They will issue demand. They'll investigate your trading history, and they'll consider, have you breached any of your duties as a director? And again, you can be personally liable for all of the creditors if you have. They will look at the transactions over the last 6 years and do a thorough investigation. They'll look at assets, they'll recover them, they'll sell them. It will be a burdensome process to go through. And sometimes I found that creditor-appointed liquidators can be overly zealous. I've seen cases where directors have been pursued for breaches of director duties at such a small amount of money that it's just completely uneconomical. Creditors can never benefit. It's just all going to go on liquidator fees. Those are the types of proceedings that I've seen being issued in those types of liquidations. What you might want is a liquidator who's going to be a bit more balanced in their view, obviously comply with all of their ethical obligations, investigate what's necessary, but do what's commercially viable for creditors. So in my view, regardless of which pathway applies, ignoring a statutory demand is the absolute worst possible strategy. Now, if you do receive a statutory demand, I recommend getting expert advice and getting that as early as possible. There are some very strict statutory timeframes that apply once you've been served with the statutory demand. The delay is not a good strategy. We offer an initial consult at Norling Law where we can go through the situation, we can go through the options and give you a tailored strategy for your situation.